from International Islamic University, Islamabad, Pakistan. He also possesses a postgraduate diploma in law from the Kenya School of Law, as well as master's in governance and democracy from the University of Nairobi. Sheikh Sukian is currently the senior principal Kadhi and is also the deputy chief Kadhi of Nairobi Kadhis Courts. He holds extensive experience in Islamic banking. He is a trained certified Sharia advisor and auditor of AOFI. He is a member of the Sharia supervision at Barclays Bank, now ABSA. He's also a Sharia advisor at Kenya Commercial Bank and is the chairman of Sharia Supervisory Board of Lab Fund. Sheikh Sukian is a Sharia advisor, a consultant, and a trainer of a number of corporates and law firms. I wish to take this particular opportunity to be able to introduce him, to take the floor, and to be able to present. Sheikh Sukian, welcome.
Thank you so much, Brother Yusuf. Thank you so much, Madam Chair, Madam Helen. Thank you, members who are this afternoon honored us with their presence today. Thank you so much. Without further ado, as introduced by Brother Yusuf, I want briefly just go directly to what we are supposed to discuss this afternoon. Kadhis Court, the background of the Kadhis Court. To begin with, the court, or rather Kadhi means is a judge. Kadhi is an Arabic word which means a judge in simple terms. And the word Kadhis Court is used all over and is written in various ways, but in our case, as in Kenyan jurisdiction, it's written as K-A-D-H-I. I think it has a root in Swahili. And in various other jurisdictions, Kadhis Court has been used, such as Ethiopia, even Tanzania, Zanzibar, and also other countries. But they write in a different format, maybe according to their dialect, in the local dialect. And the history of the Kadhis Court in Kenya is quite long. Basically, we can say it is the first, or the rather oldest, formal judicial system which operated in part of our country, Kenya. That is the coastal area. As far as 13th century, the historian found the operation of this court along coastal towns such as Mombasa and Lamu. The history is well captured and recorded. Kadhis, some of the Kadhis were seen those days around 13th century in performing Hajj in Mecca. Kadhis from Lamu. So this institution is a very old institution, and during those days before the advent of the colonial, it used to have unlimited jurisdiction, criminal, civil, family, and everything else that normally a court of a land normally discharges. So, but after the advent of the colonials, the power of the Kadhis Court were reduced gradually to the extent of limiting to what we have today. What we have today, of course, the jurisdiction of the Kadhis Court and the existence of the Kadhis Court was captured, well enshrined in our independent constitution of 1963. And it survived many other amendments of that constitution, and until it also survived in the current constitution of 2010 and Article 170. Of course, prior to that, under Article 169, Kadhis Court has been listed as one of the subordinate courts that we have which are the magistrate courts, the Kadhis Court, the courts martial, and any other court or local tribunal as may be established by an act of parliament. And that is the Kadhis Court briefly. It survived, and its jurisdiction is well defined also in the old constitution as well as the current constitution, and it is limited to this area of the personal status. Now, part of the personal status, what has been listed is the issue of the marriage, divorce, and inheritance. But our understanding is that both all those three which are listed, the marriage, the divorce, and as well as the inheritance, are just an example of the personal status. Otherwise, personal status is so wide in the Islamic context because personal status in Arabic is called al-ahwal al-shakhsiyya. It's a personal matters, which are so many. And it covers issue of the children, their welfare, and a lot of other things. But of late, in our jurisdiction, in 2022, there's a Waqf Commissioners Act, which have been enacted or rather reviewed. It established also donated power to handle issues or dispute related to Waqf to Kadhis Court, and that is under section or section 29 of Waqf Commissioners Act, which is Act number 8 of 2022, which says any matter or dispute relating to a Waqf shall in the first instance be referred to a Kadhis court. And the issue which surround there are a number of the issues. When talk of the marriage, there are a lot of issues around there. If you open up that box of the marriage, there are a lot of eggs inside there, because there's an issue of the pre-arrangement of the marriages, dispute even before the marriages, after them, during the marriage, after the marriage, right and the privileges within the marriages. A lot of other things are inside there, including, of course, the matrimonial properties and the matrimonial act, and many other things which that affect the families. If we come to the divorce, it's also the same thing. Divorce process from the beginning to the end, and the rights that are associated, which include the EDA and the rights that follows, which also include what is known as damages after the divorce. They call mata, or compensation that is given to the wife after the divorce. Inheritance is too wide. Is a too wide areas. This is the area where Kadhis Court, despite the fact that it's a court which is a subordinate court, and as we know, most the subordinate courts like magistrate have got limited jurisdictions with relation to the to pecuniary jurisdiction, but the Kadhis Court in this area is left with unlimited jurisdiction to handle billions properties that involve or worth billions of money. That is the jurisdiction of the Kadhis Court. And then also, the Kadhis Court is also given under the Civil Procedure Act power to sit with the High Court in the event of an appeal from the Kadhis Court to the Superior Court as an assessor to help the judge on the point of the Sharia. So here also the Kadhis Court, the Kadhis help, the Chief Kadhi or two Kadhis normally help in the judges when it comes to appeal. So basically, that is the jurisdiction of the Kadhis Court and a basic history of the Kadhis Court. I beg to stop here. Thank you.
Thank you so much, Honorable Sukyan. Thank you for the illuminating presentation. Now, members, feel free to be able to ask any questions. We'll be able to revisit the questions. We'll have Q&A forum upon presentation by the second presenter. Allow me to be able to introduce the second presenter of the session. Her name is Halima Wanjiku. Halima Wanjiku is an advocate of the High Court. She is a practitioner of the Kadhis Court. She's the managing partner of Halima and Associates Advocates. She was admitted to the bar in 2017. Halima is an Associate Chartered Institute of Arbitrator. She's also a company secretary. Miss Halima, welcome. You can take over.
Thank you. So, good afternoon, everyone. Today I'm going to talk about to introduce you guys to the Kadhis Court rules 2020. Basically, the rules were promulgated subject to Section 8 of the Kadhis Court rules, which provide that the Chief Justice can make rules on procedure on filing matters in the Kadhis Court. The rules are not very much different from the rules provided under the civil procedure rules, but at the same time, Islamic law practice and Sharia are used in determining procedure in the court. I'm going to start with part one of the rules, which are the preliminary section, which is the application of the act of the rules, which applies to Islam, to all matters that are filed under the Kadhis Court, which we have been told about the jurisdiction of the court by our Honorable DCK. There's also provision for overriding objectives of the rule. These are also in line with the civil procedure rules, where we have the oxygen principles. And at the same time, some of the Islamic principles that are being considered are enjoining the good and forbidding the evil, certainty of matters, and certainty cannot be dispelled by doubt. Freedom from liability is a fundamental principle. To make the other principle is to ensure that injury is removed. There's the principle of arbitration and customs to be used to make sure that some of the matters are determined outside court. There's also provision on non-compliance of the rules. The rules provide that the court can make adverse orders where a party does not comply with the rules of the court. This, of course, this cannot, of course, make the proceedings fatal. The same can be set aside in line with Article 159 of the Constitution, whereby procedural irregularity cannot make fatal the proceedings. Where court has made adverse orders on non-compliance with the rules, an application can be made through notice of motion for the court to set aside such orders, and of course the court will look at the fairness and justice in setting aside such matters. Section 2 of the rules deals with the proceedings, to two parties of the proceedings. Of course, there is the petitioner and the respondent. At the same time, there is the proceedings of third parties, whereby a third party can be joined in as a party to the suit. The application is made through notice of motion. The same is served and it can be heard before court. There is the gender of parties whereby there's gender of party whereby a party can apply before court to join in as a petitioner or a respondent. The same is made through notice of motion. The court also has to look at the parties on record on issues of misjoinder of parties. Any application can be made, and the same can be looked into by the court. There's a provision on abatement of action. Abatement of action is whereby the action has taken too long, or maybe due to incapacity of an applicant or the claimant or the petitioner, the proceedings have not been able to proceed. So a party can make, an opposing party can make an application for the court to dismiss such suit or application due to abatement. The court has protection provisions of people under disability. So the court provides that a person under disability can approach court through a guardian or a next of kin. That also applies to minors. Some of the protection provision under this are that any settlements or compromise made shall be done by leave of court, whereby a person under disability is involved. Any property or money recovered shall be paid through the court, or the court may decide. The court shall also ensure that ensure that the interest of justice is met, and to make sure that there is no instance whereby the person under disability suffers any injustice due to the guardian. In such a case, then the court may remove or replace a guardian where necessary, where they seen that there is injustice that is being made. When it comes to minors, they can also sue through a guardian or next of friend. The court provides for a procedure where a minor attains the age of majority, and we are provided that once a minor attains the age of majority, they can decide to either proceed with the proceedings or withdraw the case. Withdrawing the case will not affect withdrawing the case will not affect any of the party, the minor or now the who has attained majority. The costs will not incur to him. The cost will not be incurred towards him, but also court will look at how the other parties will be affected if this matter has been withdrawn. And if the minor decides to proceed with the proceedings, an application will be made so that the guardian can be removed from acting for the minor, because they are now no longer a minor. Commencement of proceedings under Part 3 of the rules requires that there is a form KC1 in terms of a petition that parties can file a matter through petition, and also there is entering an appearance. The rules provide for forms for filing, for response, for summons to enter appearance, for entering appearance. The rules are very specific about the format, and the same can be found in the schedule of the rules. Summons should also be taken out for the respondents, and the same should be signed by the registrar or executive officer, as the case may be. So an application for extension of summons, you know that summons are valid for only 12 months, and application for extension, this is the case whereby maybe the respondents cannot be found. They can be valid for 2 years and after extension. Service of the summons should be done within 15 days, and appearance served to be entered within 15 days. In cases whereby where a party does not appear, a warrant of arrest can be issued for them to appear before court. The same applies with witness summons, where a party wishes that the court issues witness summons. The same can be filed and sealed by court and to be served to the witnesses. If the witnesses do not appear, warrants of arrest will be issued to the effect. The place of suing, when it comes to filing of divorce and matrimonial proceedings, the rules provide that the place for suing is where the parties where either of the party habitually resides. So if either party is in Nairobi, the other one is in Nakuru, either of the two places a party can file in either of the two places for the divorce proceedings. When it comes to inheritance, the rules provide that where the majority of the estate is, that's where you file, or where majority of the beneficiaries reside, then you file the petition there. Where parties do not agree as to place of filing, the court will determine the same on application by a party. Service of summons are not very different from what is provided for under the civil procedure rules. Service should be in person unless otherwise directed. Service where the party is represented, service is done to the advocates on record. Of course, other service should be done through a process server. Substituted service can be done through application to court, and we have the same that are provided for under the civil procedure rules. Of course, the rules also provide for service outside Kenya. The services should be sealed by the High Court of Kenya and forwarded to the Ministry of Foreign Affairs, and the same is forwarded, translated if necessary, or otherwise forwarded to the country so that it can be transmitted to the respondent. The rules also have made provision for appearances. Where a party is served, they have 15 days to file appearance, and a further 15 days of file response thereof, in person or in advocate, or if a person is under disability, they can file through a guardian, or if a person is a minor. In the absence of either party, when the matter comes up for hearing, the court may dismiss the matter. If the respondent does not appear, the court may proceed ex parte, provided that there is an affidavit of service showing that the respondent was duly served. If the petitioner does not appear, the court may proceed to determine the matter and hear if any counterclaim, if any. The court may also, on its own motion, dismiss any matter for want of prosecution if the pleadings have not been completed in 1 year, or if the matter has been filed for 1 year and no action has been taken for a full year. A lot of matters we have seen this action by the court a lot, whereby matters are dismissed where no action has been filed. The court has been very active in this regard. Hearings. The hearings of the court are usually in open court, unless otherwise directed to be heard in chambers. We have instances where we have matters that are heard in cameras. Some of the divorce matters are usually heard in cameras, and this is something that the court has already discussed. And upon application by a party or an advocate, a matter can be heard in chambers or in camera. The order as to which a suit can be heard, of course, it starts with the petitioner. They open their case, they call their witnesses, and at the same time, after that, once they close their case, the respondents come in, open their case, and proceed. According to Islamic law, there's something about taking oath, whereby there is hearing by oath, whereby the petitioner is required to take oath, and if she does not, or he or she does not take oath, it means that they're not providing their evidence. The respondent may come in and take the oath if he or she opposes the claim. If they do not oppose the claim, then a judgment can be made to that effect. But if they oppose the claim, the petitioner will also be required to come in and take oath and give her evidence. Otherwise, judgment will be given in absence of the petitioner's testimony. The rules provide for recusal of a Kadhi, which can be done either by the court's own motion or by application by either of the party, and the court will look at the merit of the same and make a judgment ruling to the effect. There is the provision for disqualification of a Kadhi to sit in a matter, and the rules provide that if a Kadhi is the spouse or relative or an in-law of a litigant, if the Kadhi or his spouse has an existing dispute with the litigant in another matter, the spouse, if the Kadhi is a guardian, trustee, presumptive heir of a litigant, or if the spouse of the guardian or trustee of a litigant or relative, or an in-law up to the fourth degree of the guardian or trustee or litigant, if the Kadhi had presented one of the litigants in the case before the Kadhi joined the judiciary, this is in cases whereby the Kadhi had been an advocate before, if the Kadhi had appeared as a witness in a case or had engaged in any investigative action therein, and if enmity or friendship exists between the Kadhi and the litigants such that it's likely to affect the Kadhi's impartiality. Of course, these rules basically say in cases where there is apparent bias, a Kadhi should disqualified in either suo motu or through application by one of the parties. The next part, which is part 7, provides for judgments, and of course, all judgments should be in writing, should be dated and signed by the presiding Kadhi or the Kadhi of equal rank if the presiding Kadhi is not available, as provided in the rules, the same as provided under the civil procedure rules. The judgment should contain the names of the parties, the petitioner's claim, the respondent's response or counterclaim, the issues for determination, a summary of evidence given by the petitioner and respondent, the court's finding on the evidence submitted in accordance with Islamic law, and now the orders of the court. Review of the judgments of judgment on court's own motion. The rules recognize the fact that a Kadhi can realize that there was a mistake or misapprehension of facts with a judgment that he has delivered, and on his own motion can review the judgment. The same, a party can apply for revision of review, such as provided under the civil procedure rules on discovery of new evidence, where there's a mistake apparent on the face of the record, and or in cases whereby the judgment or ruling or order requires clarification or any other sufficient reason. There is judgment by concept, or some we call suluhu in Kiswahili. Where parties agree on the matters in issue and agree to a settlement, a judgment in consent can be filed before court, and the matter can be closed. Order for installment. This is one of the way settlement can be done. A judgment debtor may apply to court to pay in installments or for reduced installments. So where the judgment requires an action to be done other than payment of money, you shall state the time within which the act is to be done, and such time shall be reasonable in the circumstances. The other part provided by is the enforcement of now of the judgment. For making of for payment of money, there is seizure and sale of property. There is transfer of debts. Transfer of debts applies by a third party owes the judgment debtor some money. Therefore, the judgment creditor will make an application to court in the required format for the debt to be transferred to the third party. The same will be filed and served to the third party, who has 7 days to reply to the same. And if the court finds that the third party is indeed indebted to the judgment debtor, the same can be attached for satisfaction of the judgment. A judgment debtor can be committed to civil jail, and whereby the judgment debtor is a body corporate, then one of the officers or director of the corporation will be committed to civil jail. Where the judgment involves giving a possession of immovable property, an order of possession or eviction can be given, or an order of committal to civil jail and can be given. Part 8 of the rules provide for appeals, and of course appeals lie to the High Court, since the Kadhis Court is in the same rank as the Magistrate Court, and the right of appeal is within 30 days, whereby a notice of appeal should be filed and served, indicating whether the appeal is on part or whole of the judgment. Now, part 10 of the rules provide for interlocutory proceedings, injunction, and interim orders. The same to be applied to court through Form KC 18, and the same can be applied ex parte unless the court directs otherwise. The court, some of the interim orders or application that can be did is preservation of any property, safeguarding the rights of any party, facilitating the trial for hearing through security. Such application can be had orally, can be made orally in court. And the court can make orders for the other parties to be given a chance to be heard and determination made. And there is an application for interim orders of custody, also called Hadana, and the same can be applied through a notice of motion through court, and the court will make appropriate orders, taking in mind the interest of the minor as provided for under the Children Act. There is also the interim orders of maintenance for the children and also for a wife, whereby the respondent, of course the husband, has not been providing. The same can be given by court in the interim as the matter is proceeding. Now, the rules provide for evidentiary procedures of all matters that are in court. So Islamic law on evidentiary procedures will be observed. The burden of proof lies on the claimant, and the person who disputes facts takes the oath. So burden of proof lies with the claimant, and the person who disputes take an oath. Now the respondent takes an oath on any facts that is disputed. The court may call any person to provide evidence, provided that no party is obliged to give evidence against his will. I think this is one of the places whereby it differs from the Evidence Act, say on compulsion of giving evidence. No one can be compelled according now to Islamic law. Evidence may be given by oath or affirmation, the same as the other proceedings. Oral evidence by witness may be provided in open court to ensure that there is examination of the witness. And there's called evidence by oath. I think I've mentioned this, whereby the petitioner is supposed to take oath and give evidence. If he or she does not have evidence, the respondent may be required to take oath and give evidence if he opposes to the claim. If the respondent takes the oath, the claim may be dismissed. If he or she disputes the denies to take oath, the court may ask the petitioner to take oath upon which the court may make a decision as to what is just and fair for the victim. Now, there's giving testimony. Each party shall be heard individually in open court, but in the absence of other witnesses who are yet to testify. The court may ask any question it deems necessary to shed light to the truth. If a witness cannot appear for any reason of incapacity, the court may arrange to visit the witness to get his or her testimony. The parties to the case are not competent witnesses to their own cases. That's what the rules provide. A witness who is dumb or using foreign or local dialect may give his or her witness in any manner which is intelligible, such as writing, signs, or by an interpreter. A party who had been unable to file any witness statement and wish to rely to a certain witness may ask for leave to file witness statement out of time, and the court will consider if it's just and expedient to accept such. The court may require any evidence to be authenticated. The court may call upon any author of a document or deponent on an affidavit for examination on the facts of the facts contained in the documents. The rules provides for discovery of documents. So where the court finds it necessary, it may order any party on oath, either orally or through affidavit, to appear before court and state to appear before court and state whether they are in possession of any document or know where any document is, or if they have a power to adduce that evidence before court. The same applies with the inspection of documents. Any party shall be entitled to inspect a copy of any documents in possession or power of another party, and that party may be called to court for examination. Any original documents that are filed before court that a party wishes to rely upon, a copy of the same needs to be filed and served to the other party. Now, dissolution of marriages. Now, the rules provide that the marriage should be the application for dissolution of marriage is through a petition supported by affidavit, provided by a list of witnesses and their statements, and file any documentary evidence that needs to be relied upon. There's some types of divorces. We have 4 types of divorces, 5 types of divorces that are provided for. One is talaq. Now this is whereby the husband gives the wife a talaq. The right that usually in Islamic law, the husband has the right to divorce his wife, but now they'll have to apply to court under the registration of divorce for the divorce to be registered. the court will listen to the parties, determine whether the divorce is valid according to Sharia law. If the same is valid, the Qadi will issue a divorce certificate. If the divorce is revocable, that is, if it's the first or second divorce, then the certificate may not be given. But when the divorce is irrevocable, the final, the third one, the court will issue a divorce certificate. There is a whole, which is where the wife seeks divorce, or in other words, they buy the divorce from the husband. If the parties agree on how this on the buying part, on the amount to be paid by the wife, the same they'll apply to court for the same for the divorce certificate to be issued, and the court will determine whether the same is valid and issue the divorce certificate. And then there is divorce by lian. That's an Arabic word, whereby it's an oath on allegation of adultery, whereby any party, either of the party is said to be adulterous. There are procedure whereby you have to prove adultery, and in Islamic law, they say you need to have, if it is not, if you do not witness it yourself, you're supposed to have 4 witnesses to say that they witnessed the adultery. So there's an affidavit to be filed, and if the same is proven to be true, then a divorce certificate will be issued. There's a divorce by stipulation. This is whereby a parties made an agreement, and if maybe one of the parties, this is when they were getting married, made an agreement, and if one of the terms has been breached, I would say, they may apply to court for dissolution of that marriage. The court will look at the facts of the case and decide whether if a divorce will be valid or not. There is a divorce by fasakh, and this is whereby a married woman can apply for decree of dissolution of marriage. This is done whereby the marriage has broken down and the husband refuses to give talaq, and maybe does not fall under hul. Now they can apply for judicial separation. It's also called judicial separation by the court. And now one of the things that court really look at, the Kadhis Court look at, is preservation of the marriage, and they try as much as possible to see whether the parties can reconcile. They try to do mediation to see where the parties they can reconcile, where the parties are represented by advocates. The Kadhis usually insist that the advocate try and help the parties resolve the same. If not, then the divorce certificate is issued according to Sharia law. When it comes to division of matrimonial property, the same is done and through a notice of motion, and the court will make this. Now that this is if it's within the divorce suit, then the court can, the same can be made through a notice of motion. If it's on its own, then an application can be made as a miscellaneous application, of course, also notice of motion on its own, and can be heard and determined on its merits according to Sharia law. When it comes to also issues of divorce, there's something called muta, which is a gift to divorced women as consolatory gift. This is provided under the Quran, whereby the husband divorces the wife, they're given now this gift. This is one of the things that they ask as prayers when they're applying for divorce, muta, gift to the woman upon divorce. Then there's maintenance of the wife, where in this during the subsistence of marriage, the husband does not provide for the wife and the children or the child. An application can be made to court for orders for the husband to maintain the wife and the minors. The same is done through a notice of motion. When the woman has already been divorced, a woman can make an application for edat maintenance. Edat maintenance is during 3 months. There is a provision for it that 3 months after the divorce, the husband is supposed to cater for all the needs of the former wife. Also, if there's any other rights that the divorced woman is entitled to, they're supposed to apply to court for court to make a determination for what is just and reasonable. Yes, when it comes to costs, of course, costs follow the event, and costs are at the discretion of the court. The court may make any orders it seems fit. There's also the provision on contempt of court, whereby a party that disobeys court orders, an application can be made to court for appropriate measures on contempt of court. The same is as provided for under the civil procedure rules. The rules, as I conclude, they in its transitional procedures, it provides that anywhere where there is a vacuum, where there is a lacuna in the rules, we fall back to the civil procedure rules for guidance. Then finally, there is the issue of inheritance and succession matters. The rules provide that the part 4 of the civil procedure rules of the Law of Succession Act, will be followed in terms of succession matters, as long as it does not clash with the Islamic law. Procedurally, that is in applying for grants, for letters of administration, intestate, letters of administration, testate, and confirmation of grant. The Law of Succession Act, and by extension the probate rules, will apply in succession matters of persons professing the Islamic faith, and Kadhis can confirm the same, just as the other as the High Court confirms. The Kadhis Court has powers to confirm letters of administration, testate, or probate. And now that is the end of my presentation on the rules of the civil on the Kadhis Court Rules 2020. Thank you for listening.
Thank you, Ms. Halima, for the presentation. I believe it has been informative. I've gotten concerns from a member. There was a bit of disruption while the presentation was being made. We apologize for the same. We can now transition to the question and answer forum. I have a couple of questions from members. I will allocate the same based on where it emanated from. For Sheikh Sukian, the question that we will request you answer is, there is a question from a member: what does personal status of the parties entail? That is the first question. What does personal status of parties entail? There is also another question and from Vera. I understand that both parties should be professing the Muslim faith and submit to the jurisdiction of the Kadhis Court. What happens in a case where midway, while dealing with an issue on custody and maintenance of a minor, one of the party denounces the Muslim faith and files a PO or an application in the High Court for the matter to be stayed or transferred and determined by the Children Court and not the Kadhis Court? I hope, Your Honor, you've been able to get the question, the second question.
I'm following very well. Thank you.
Okay, so far those are the questions. For Ms. Halima, the question that is applicable to you is, you indicated that if a party is aggrieved with a decision of the Kadhis Court, they appeal to the High Court. The question from a member is whether once you appeal to the High Court, you have a right to appeal to the Court of Appeal.
Yes,
On what? So I'll invite Sheikh Sukian to answer the two questions, and then Madam Halima, you can be able to answer that question. Members, if you have any questions after these particular questions are answered, you can raise your hand and you can ask the question. Thank you.
Thank you so much, Brother Yusuf, and thank you so much, Madam Halima, for the extensive submission on the rules that governs the Kadhis Court. And thank you so much also our esteemed listeners, especially the questionnaire. Personal status entails what? What is provided in law, what's provided in law and the letter of the law, if you see at it, there are three issues there only. One, the law says personal status, the jurisdiction of the Kadhis Court is limited to the occasion, like that's how the Constitution says, and also the Kadhis Court Act, Section 5 of the Kadhis Court. It's just a copy paste of the Constitution. Article 175 says the jurisdiction of a Kadhis Court shall be limited to the determination of questions of Muslim law relating to personal status, marriage, divorce, or inheritance in proceedings in which all the parties profess the Muslim religion and submit to the jurisdiction of the Kadhis Court. That's what it says. And Section 5 of the Kadhis Court says also, a Kadhis Court shall have and exercise the following jurisdiction, namely, the determination of questions of Muslim law relating to personal status, marriage, divorce, or inheritance in proceeding in which all the parties profess the Muslim religion. And then it says, but nothing in this section shall limit the jurisdiction of the High Court or of any subordinate court in any proceeding which comes before it. Now, what the three items are very clear here. Marriage is very clear, and what it tells, what in that box of the marriage is just so many things, as I earlier said. Divorce, probably also, also inheritance. It involves a lot of things. What has not been very clear in our jurisdiction is what entails personal status. My understanding of the where this personal status come from itself, I said it's called ahwal shakhsiyya in Arabic, because the background itself, the history is an Arabic or the Muslim Sharia law itself. It entails that personal status are the cases, issues which are personal in nature. And these ones, marriage is a personal, divorce is a personal, inheritance too is a personal. And there are also many other things. It involves endowments, it involves gifts, it involves issues of the children, relationship between the parents and the children, relationship between the spouses, a number of other things. Cannot be limited, and it's not an issue that can be actually limited. There are so many merits in my understanding. Now, of late, in our jurisdiction, the legislature, with its wisdom, enacted Waqf Commissioners Act, or the Waqf Commission Act. It now included the Waqf Commission clearly. So when we're able to interpret in ourselves as a Kadhis, we find personal status covers a lot of area. The area of the concern that comes up every other time, and it goes for an appeal, and the decision of the superior courts is divided, is whether issue of the children, the welfare of the children, is part of the personal status or not. This is what we are dealing with as court, that we believe that the issue of the children is part of the personal status, and we do have that jurisdiction as Kadhis. And the Kadhis Court rule, the Kadhis Court rule is also very clear on that. It provides clearly at Rule 113 and 114 is very clear that the issue of the children, be it their hadana, that is custody of the children, or maybe nafaka, that is the provisions of the maintenance of the children, is well captured in those rules, Rule 113 and Rule 114. Therefore, this is an area that normally is being quite debated. Still, it's not very clear. but we strongly believe that personal status covers a lot of quite a wide range of personal issues. The Kadhis Court Act at its preamble, it says, it's an act of parliament to prescribe certain matters relating to Kadhis courts under the Constitution, to make further provision concerning Kadhis courts and for purposes connected therewith and incidental thereto. So the statutes and the Constitution never captured everything. And that's what we believe. Everything that covers what the personal status is. They mentioned only a major one, which was then appealing to them, which is the inheritance, marriage, and divorce. The reason why I made actually my presentation earlier brief, I wanted just people to provoke us with questions so that we respond to the burning issues which are at the corridor of our justice system or in our court. The issue of the professed Islam is one of the conditions which from the back door was introduced in our constitution. Let's say back door. I'm saying that deliberately because it's not an issue which has been debated during the constitutional debate that took several years. We just found it at the conclusion that this area has been included. We found it this quite authoritative to the existence of the Kadhis Court because somebody could say even we did not submit to the Kadhis Court, and that is enough. But now the issue of the profession in Islam, at what point this would be considered that parties profess Islam? Is it at the beginning of the case, or maybe anytime somebody can come out and say that I'm not a Muslim, or would it be at the time when maybe the issue of the marriage, when the parties got married, or is it or maybe what we consider is for in the event maybe in case of inheritance, do we look at the person who died, his property, how can it be handled, or you look at the beneficiaries? How do you look at it? There is no clarity on this. There is no clarity on this in law. As far as I'm concerned, the law says that somebody must be professed in Islam. That's what the law is saying. But if I would have interpreted, this must be at the time when the matter is filed, when the case is filed. It can also work that, for example, when the party married, were they both Muslims or not? Did they enter that right that we're dealing with, the marital right that we're dealing with, okay, while they were Muslims or not? And that is what would convince me. This right that we're talking about in court is a right that is established when? What was the status then? That is the thing that that is the status that would convince me. When we come to inheritance, still is the same thing. Although there's a decision of the High Court earlier, I think in Kwale. My conviction is that the law is very clear. The property of a deceased Muslim must be administered or inherited in accordance with the Muslim law. Okay, so the focus is what determines is the person who died, the owner of that property. Okay, that's the person that you look at, not the person that who is claiming a right of inheritance or whatever right on that particular property. So the focus is if that person is a Muslim, all right, whatever that you profess, okay, it doesn't really matter, because what's important is how should this property in accordance to be administered and also distributed, because the end result is the distribution of the estate, inheritance itself, right? So the focus is, and the law is very clear on that, is that what was the religion of the deceased at the time of his or her death. That should be the focus. Thank you.
Thank you so much. I believe you've comprehensively responded to the two questions. Madam Alima, you can be able to proceed and respond to the question that was directed to you.
Yes, thank you, Yusuf. Now, the right of appeal is the same as the other courts of the magistrate courts, whereby the first appeal lies with the High Court, and the second appeal will will lie with the Court of Appeal on matters of law alone. The High Court will deal with appeal on matters of law and fact. Yes, so the right of appeal does not end with the High Court. You can appeal also to the Court of Appeal on matters of law. Yes, I think that was that.
Very well. While you're still on the floor, there's another question for you. Can an advocate of the High Court who does not profess the Islamic faith or who does not have any knowledge in Sharia practice at the Kadhis Court?
Yes, any advocate is at liberty to practice at the Kadhis Court. At the end of the day, as counsels, we know our sources of the law. We go back to our research and do appropriate pleadings. But any advocate can practice under the Kadhis Court. You don't have to be a Muslim to be a practitioner.
Thank you so much, Madam Halima. Iona, there's another question for you from a Koth Magak advocate. In inheritance of a deceased estate, is there an order of priority? That is the first bit of the question. The second bit of the question, what happens where the deceased had children who were born out of wedlock?
Okay. Thank you. Thank you so much, Wakili Asante Sana, for that question. That's a very, very wonderful and good question. Today we'll be learning some Muslim law, inshallah. Order of the priority in inheritance. And in Islam, we have a very comprehensive rules that governs the inheritance. There are quite wide range of relatives who are entitled to inherit. The first category are the roots or the parents of the deceased. And then the branches who are the children. When we talk of the children, we also refer to the grandchildren. When we refer to, when we talk about the parents, we also talk about the grandparents. There are rules that governs all that. And then we have other relatives, such as the siblings, the brothers and sisters of different categories, right? By different categories, I mean there are some siblings that we share both parents. There's some siblings whom we share only one parent, be it the mother or the father. So all of them have entitlement, but they must meet a certain condition. When all the people who are entitled to inherit, even your uncles, the paternal uncles, they're also entitled to inherit. There is a certain, under certain circumstances, even your maternal uncles can even entitled to inheritance. But when all of them are present, the following categories are always entitled to inherit. For example, somebody passed on, he is survived by his two parents. The two parents must always inherit in accordance with the portions granted to them by the Holy Quran. The parents, your children, right? Your biological children, not the grandchildren, also they are entitled to inherit. These are legal children we're talking about. The legal children who are born within the wedlock, right? These are also entitled, and the spouses, either of the spouse, if one of them die, these people are always entitled. In their presence of the children, in the presence of the parent, in the presence of the spouse, right? The rest of the relatives have no place. So the priority is that the parents, the spouse, and the children have got the higher priorities, right? The rest will come. Even the grandchildren will not inherit where there is a biological child in place, right? Especially the male child. A child who is born out of wedlock, and that is true and established, has the right to inherit only his mother or her mother, not the father. That's the position of the Sharia. Hope I have addressed those two questions. Thank you.
Thank you so much, Sheikh Shukran. I believe you've addressed the same. In the interest of time, I'll refer one question to you so that we can conclude. The question is from Jacqueline Advocate. Can a widow demand allowance from the deceased, that is the husband, estate, from the in-laws if dowry was not paid?
Very well. Allowance. The moment someone dies, the ownership of that property by operation of law, whether you go to court or not, ordinarily, has shifted to the heirs. So there are several rights that is connected to that estate the moment that you die. One, the first thing is the burial expenses of the deceased from the estate. It must be a moderate send-off. Second is the debt, an established debt, the liabilities of the deceased which he incurred or she incurred during his or her lifetime, right? A third party right must be, first of all, settled. Third is the execution of will, if any. If the person, the deceased, left a valid will, acceptable in law, that will must be executed. And the will is not absolute. What you can will should not exceed or more than a third of your estate. Second condition, you should not bequeath anything to people who are ordinarily entitled to inheritance by operation of law. You can give to others, to charity, but should not still exceed a third of your property. Finally, whatever left is now subject of the inheritance to be inherited by those who are entitled to inherit. Now, you are the wife, husband died, he owes you certain debt like dowry. It's part of the debt you should be paid first out of that. So that's your right, you'll be paid. Or maybe there is a maintenance right which you did not pay for all for many years or for many months, and the court has given that order. That is still a debt, must be settled out of that. What left then, out of that you can't claim anything apart from that, because you are also entitled to an inheritance if you are a wife. Thank you.
Thank you, Honorable DCK. I now wish to invite you to be able to give a vote of thanks.
Many thanks, Brother Yusuf, our moderator. Many thanks, my sister, Halima Wanjiku. Many thanks, our esteemed participants and the listeners who have joined us this afternoon. And many thanks for your questions. I hope we have managed to make some enlightenment on whatever that we're discussing. We are not taking this for granted. And we really thank you so much for supporting Kadhis Court. It's good that you understand how this court operates. Many lawyers may not be having that maybe that background of the especially Sharia law. Most of the lawyers, when they come, they normally so much make a lot of emphasis on the procedures and the technicalities. But I also appreciate equally that many lawyers also are trying their best, really to make a good research on the Sharia questions and the Sharia rules. So this is an area which is growing. We need you to grow together, all of us. This area of the Sharia is quite wide. It's not something that's that simple. And of late, of course, now this introduction of the issue of the waqf, we need to familiarize ourselves with what waqf is all about. And we also have, of course, the Islamic banking, Islamic finance around us, which all of them are built around the Sharia law. We have no otherwise, as practitioners, we have no otherwise as practitioners, but must at least have some knowledge of the Sharia law. Otherwise, thank you so much. May God bless you. And thank you so much, Madam Chair. What's her name? Madam Chair Helen. Helen, thank you, Madam Halima. Thank you, Mzewetu, Brother Ali Advocates. Thank you so much, all our esteemed and clients and lawyers, practitioners. Until we meet again. I hope the chair is still with us. He can now give an announcement that when will be our next meeting again. Thank you so much and God bless.
Thank you so much. Thank you, members. This marks the end of the session. I can be able to see that this particular session has generated a lot in terms of inheritance and succession matters. I believe this is just one of the sessions. We'll continue to have interactions and sessions. Thank you so much. Have a lovely evening.
I hope before you close, Yusuf, I hope those questions and reactions have been recorded and reduced into maybe writing. Sometimes maybe we may have them in our reports.
I'm informed that they are being recorded. The same will be availed by the LSK Nairobi branch.
Thank you. Thank you. And Allah bless you. Santene Sana. Madam Leila, we don't hear you. Where are you?
Good afternoon, Kian.
Good afternoon. Good afternoon, Leila.
Thank you for a lovely session. Thank you to our members who have joined this afternoon. And as I've indicated, we've seen there's a lot of interest in succession and inheritance matters. We'll have a subsequent session when we can have an in-depth discussion on that topic. However, if there are other areas that one would like us to consider, please feel free to reach out to the Bar Bench Committee and LSK. Thank you, Honorable Sukian. Thank you, Halima and Yusuf.
Thank you. Assalamu alaikum wa rahmatullahi wa barakatuh.